Hi there, my name is Richard Marler, and welcome to my mediation and therapy practice. I thought I'd take a few moments to speak to the significant changes in Australian family law that are coming into effect on 6 May 2024. We're seeing a significant change to the way that the court is going to determine the best interests of the child. So, previous to this amendment, the court considered 16 factors. Two were primary considerations and 14 were secondary. Now this is being simplified and reduced from 16 factors down into 6 factors, and then an additional factor for Aboriginal and Torres Strait Islander children. So I'd like to speak first to these 6 factors. So factor 1 is safety. And in my view, there is a significant change that is coming into the legislation. So the legislation now provides that the court must consider not only what arrangements would promote the safety of the child, but also the safety of each person who has the care of the child. Now, this is a significant shift because the prior regime simply required the court to consider protecting the child from harm, but didn't consider that if there was harm or lack of safety for a caregiver of the child, if the child wasn't exposed to that harm, then the legislation was silent to that. So this is a significant shift, and it's going to also have ramifications for parental responsibility, which I'll speak to in a moment. So we're seeing now that the court is going to have to take a broader approach to safety of the child, and not just what's directly relevant to the child, but also indirectly relevant in terms of the safety of the child's caregiver, independently of the safety of the child themselves. So indeed, it's a proactive approach rather than a reactive approach to risk of harm. Now, factor 2 is the views of the child. This hasn't changed significantly. The court already considered the views of the child. What I would say to parents is, when determining whether or not the views of the child should be considered, it's important that you have a common sense approach. Trivial or fantasy-based wishes aren't particularly useful or relevant. But if a child has the maturity and the age to speak to their living arrangements and their care arrangements and what their wishes are, and that those wishes are considered and can follow a certain logic or reasoning, then that's when they're certainly going to be taken notice of by the court. And the other point is, if at any point the safety of a child is in question, then their views are extremely important. And so that's a framework that you can use to determine whether or not you think that your child's wishes should be included in negotiations or a mediation process or court process. Factor 3 is the child's needs, their developmental, psychological, emotional and cultural needs. Factor 4 is each parent's capacity to provide for the child's needs. Factor 5 is the benefit to the child having a relationship with their parents. And the final factor 6 is any other matter that might be relevant in determining the best interests of the child. And then if the child is Aboriginal or Torres Strait Islander, there's a further cultural consideration as well. Now, the next point about the legislation is that it's removing the presumption of equal shared parental responsibility. And this is to correct the common misnomer in the community that parents have a right to equal time with their child, which they never have had that right. And so it's to clarify that now what parents need to be considering is whether it's to be joint or sole decision making in relation to long-term decisions affecting the child. So that would be health and education and religion and those types of issues that extend well beyond day-to-day care. So the court will now be considering whether those decisions should be made jointly or solely. The position going into court is that all parents have joint and several parental responsibility. So all parents can make decisions without the intervention of the court in relation to long-term decisions affecting children. However, if they do so without consulting the other parent, particularly now under the new regime, unless it's not safe for them to do so, the court expects parents to consult in making long-term decisions. If it's unsafe for a parent to do so, the legislation clearly provides that they don't need to consult with the other parent in making long-term decisions. So this comes back to the broadening of the safety factor of the best needs factors for children by broadening that out to the safety of caregivers, even whether or not they are exercising parental responsibility. That now means that a parent could say that due to domestic violence that's occurred throughout the relationship, that they're not able to communicate with the other parent in relation to certain decisions such as education or health, or perhaps if a parent takes a very robust view in terms of not being willing to follow, say, the Western medical model when it comes to health decisions, it may be the case now that the court's going to determine that there'll be sole parental responsibility for certain long-term decisions and joint parental responsibility for others. So that's definitely something to keep in mind in terms of understanding the legal framework that co-parenting exists. There's also a removal now of the court needing to consider equal time or significant and substantial time. So really the court's starting now with a blank canvas rather than presumptions of considering how much time children should spend with each parent. And to my mind, this is a really positive step because it takes the focus away from the parents and what's fair as between the parents, but it reminds us all of the basic family law provision that has existed for decades, that parents have the responsibility of parenting and children have the rights of being parented. So children have the rights, parents have the responsibilities, and I feel like these changes are definitely a positive move in that direction. Hopefully, this commentary provides a bit of assistance to parents who are considering the ramifications of the changes of law to their co-parenting relationship, to their negotiations, and to whether they are going to consider mediation or the court process.